During a deposition in a medical malpractice case, what can I do if the opposing attorney objects to every single question that I asked? You want to know the answer? Come join me on this walk through the beach, on the beach, as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. Okay, I had this exact scenario happen recently. I was questioning a doctor in a medical malpractice case. His attorney was objecting to practically every single question that I asked and would carefully wait until after I asked my question. He would then look to his attorney to see whether she objected, and if she did, he'd sit there quietly waiting for the attorneys to finish arguing. Now, you should know something. A deposition is a question and answer session given under oath. It takes place typically in the attorney's office, in their conference room, but with COVID being what it is, most of the time it now takes place online through a Zoom call. There is a court stenographer there who will record all of the questions that I ask and all of the answers that the doctor gives. Even though this is being done on a Zoom call, the answers that the doctor gives represents his sworn testimony, and it carries the same exact weight as if he is testifying at the time of trial. So it's critically important to understand that his answers actually represent the same type of testimony as if he is testifying in front of a court, in front of a jury. So now when I'm asking questions, his attorney, the defense lawyer, has a right, if they feel it's warranted, to go ahead and yell out objection. And there are a number of key reasons why an attorney would do that. They're doing that to try and preserve their client's rights. Sometimes I might ask a question that is not phrased properly, or it might have more than one meaning, or it might call for an answer that has two possible answers, meaning that I ask a compound question. So if I say, "Doctor, isn't it true you did X, Y, and Z on this date when the sun was shining?" Now it may be that he did X, Y, and Z, but the sun wasn't shining. So if he answers yes, we don't know whether he's answering yes to the fact that he did X, Y, and Z, or is he answering yes to the fact that the sun was shining? In that case, the defense attorney likely will turn around and say, "Objection, that's a compound question, counselor. Please rephrase your question." To which I will certainly be happy to oblige. And now I'll be more careful and ask a question that asks only for one answer. "Doctor, isn't it true on this date you did X, Y, and Z?" And now if the answer is yes, he'll say yes. And then I can ask him a question if it has any relevance or bearing to the case. "Doctor, isn't it true that on this particular date it was sunny outside?" Yes or no? So that establishes only one answer per question. There are other key reasons why a defense attorney would object. They might do it to try and throw me off track. They might do it as a strategy to distract me from focusing on the key questions I need to ask the doctor. If the defense lawyer tries to do it as a strategy to distract me, there are a number of things that I can do to stop that from happening. The first thing is, I can have an interaction, I can have a discussion or a legal argument with the attorney, telling them that what they are doing is totally inappropriate and improper. And if they continue doing that, we will call the court. However, there's another possibility. The other possibility is to threaten the defense lawyer, not with physical harm or injury, because that would be improper, but rather to threaten the fact that I am going to ask the court to bring the doctor back to now answer all of the questions that the attorney is objecting to, meaning that I believe the attorney is obstructing this deposition. It's one thing for the defense lawyer to make objections, but there are only 2, maybe 3 limited instances in which they can properly tell their client, the doctor, not to answer my question. If I were to ask the doctor questions about what he and his attorney talked about, that would be improper because it calls for confidential discussions between him and his attorney. The other time it would be appropriate for the defense lawyer to tell the doctor not to answer the question is if I ask the doctor an off-the-wall question having nothing whatsoever to do with our claims in the case or the doctor's defenses. So let's say it's a medical malpractice case, and now I turn around and say, "Doctor, isn't it true you beat your wife each night?" And the defense attorney would be well within their right to turn around and say, "Objection, counselor. That's an offensive question. I find it palpably improper, and I direct the doctor not to answer that question." That would be appropriate. And there may be one other issue which I'm not going to get into right now. Okay, so what's next? What's next is that if the attorney not only voices her objection, but tells the doctor in most instances, I don't feel that's an appropriate question, that's improper, I'm directing the doctor not to answer. What if the defense attorney keeps objecting over and over and over again to almost every single question? With some of the questions, she's not allowing the doctor to answer, and others she is. I'll tell you what I do. I tell her that it's inappropriate and legally she cannot tell the doctor not to answer the question. I will tell her that she is wrong on the law and her interpretation of it. I will tell her that I expect fully to conference the case with the judge and to ask the judge to bring this doctor back to finish answering all of my questions that you are now not allowing him to answer. And I said, listen, if I still don't get any results, I will make a formal written request to the court to go ahead and bring this doctor back, claiming that you obstructed this deposition, and I will show the judge every single time, every single line, every single page of every objection you made to almost every one of my questions. And there's case law to indicate that that is totally inappropriate behavior. So why do I share this quick information with you? I share it with you because my wife is actually on the beach picking seashells, and I had a few minutes to share this with you. And I thought it would be eye-opening to help you understand what really happens in these lawsuits involving medical malpractice, involving accident matters, involving wrongful death matters in New York. You know, I recognize you likely have questions or concerns about your own matter. Well, if your matter did happen in New York and you're thinking about bringing a lawsuit, but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.